Hi, guys. So, if you could turn in your packet for the Chapter 5 Shaping a New Nation packet, I just handed it to you today, Thursday, October 12th. If you could flip to page 11, where it starts talking about the Constitution with the Constitutional Convention. I'm just going to go through this basic stuff so to prepare you for kind of going through some of the important things on Friday, just so you have the notes and you fill it out ahead of time. So the first number one on page 11 talks about the compromises of the Constitutional Convention, and number one talks about representation. So letter A under representation asks, what did the large states want? So the large states, who are led by or represented by James Madison, introduced a plan known as the Virginia Plan. And this Virginia Plan proposed a two-house legislature with representation based on population. And the reason why they wanted based on population, first of all, they were looking to include their slave population as a part of that. And if they could do so, they would get more representation in government, according to their plan. The smaller states, on the other hand, were led by William Paterson, and he introduced something called the New Jersey Plan, which called for a one-house or unicameral legislature with equal representation for each state. So each state got a vote. So therefore, it would be equal no matter what your population was. So they had to come to a compromise since the smaller states wanted equal representation in larger states, since they wanted their population counted, would want more representation than the smaller states and thought they deserved to have that. So Robert Sherman came up with a great compromise, and that great compromise called for a two-house legislature, and it split kind of the Virginia plan and the New Jersey plan amongst these two houses. So the House of Representatives kind of encompasses the Virginia plan in that it's based on population. So the larger states like California, like Texas, have a higher number of representatives in the House. And then the second part of that, the second house is, or the second body of that legislature is known as the Senate. We still have these two houses of legislature today. In the Senate, each state has two representatives, so that's a total of 100 senators, so two representatives per state. So that means they each have two votes per state. So, for example, in Wisconsin, we have two senators. We have Tammy Baldwin and Ron Johnson. So each one of them gets a vote on the Senate floor. So again, that encompassed the New Jersey plan. So that was a compromise that was made. You can take a moment and write these down and pause the video. All right, so just to give you an idea about the House of Representatives, this is a little older, or this map is a little bit older, but it represents the 108th Congress. But as you can see, those larger states like Florida, Texas, California, New York, have a larger number of representatives in the House than, say, like Wisconsin, or even states with a smaller population like South Dakota, North Dakota, Wyoming, Montana. They each only have one, at least within that area, because their population is not as large as some of the bigger or southern, southeastern, and western states like California, Texas, and Florida. All right, so the second question was about slaves. So kind of going back to the Virginia plan, part of what they wanted was to have slaves count as part of their population. Since they are looked at as property, they wanted that property to be counted as part of the population for that state, even though they weren't exactly citizens of the United States at this time. So the North, knowing that they didn't have a very high slave population, wanted the slaves to count for taxes, but not for representation purposes, because they wouldn't benefit, because they don't have a high number of slaves, and there isn't a large need for slaves in the North. And in the South, they definitely wanted the slaves to count for representation, but they didn't want to have to pay taxes for those slaves. So again, not making them have to pay out of pocket, but also making them count towards the population. So they came up with a compromise, and this was known as the 3/5 compromise. So it stated that every 5 slaves would count as 3 citizens of the United States for taxation and also for representation. So it encompassed the Northern's needs, particularly because the taxation was included, and at least 3 of those 5, 3 out of every 5 slaves would be counted for taxes. And then it encompassed the South because, again, every 3 out of the 5 slaves would be counted towards population. Even though they didn't want the taxes, they had to make a compromise as well. So you can pause the video and write these things down if you need to at this time. All right, now with number 3, national versus the state power. And this one focuses more on interstate trade. So the Federalists wanted a national control over interstate commerce, including the slave trade. So the Federalists wanted a national control over interstate commerce. So the Federalists were the ones that really emphasized the control of national government. And they emphasized that national government should be in power. And they wanted control over the trade that happened between the states, including the slave trade. The Anti-Federalists, on the other hand, wanted state control over commerce and the slave trade. So the Anti-Federalists were very anti-national government and very kind of pro state control over commerce. So they also wanted the states to have control over the slave trade as well. So the compromise that was made was that national government would have control over interstate commerce. So any trade that occurred between the states would happen on the national level or have national control, but the slave trade would have a limit. So that slave trade would have a limit up to another 20 years. So after 20 years, the slave trade would effectively end in the United States. But that's not to say that the slave or slavery actually ended. It continued until 1865, which meant the end of the Civil War. So around 1805, it meant that our slave trade would actually efficiently end in the United States. So take a moment and write those things down in your packet. You can pause the video at this time. All right, so just a couple other compromises to make note is that only one president can serve a 4-year term. So they made the agreement that you couldn't elect 2 presidents at the same time. You could only elect 1 president. But at this time in history, there were no term limits. So if a president wanted to, again, run for president over and over and over again, they could. There were no term limits on the amount of times that they could run. But again, their terms were limited to 4 years per term. The second compromise that was made was that the president would now be the commander-in-chief of the military. So the president was the leader of the military, but could not make the decision to declare war. That decision was given the power to by Congress. So Congress is the only body of our government that can declare war, but the president is the commander-in-chief of the military. And the third compromise that was made was that a Bill of Rights needed to be added to the Constitution. So at this time, with the Articles of Confederation, each state had their own Bill of Rights, and they really wanted to emphasize that on a national level, every single citizen should have rights that are granted to it by our government. So in order to include it, they needed to get the Anti-Federalists on board, which were the people that were more for state control. So the Bill of Rights would be added to the Constitution as long as the Anti-Federalists would sign it, it would be added, which eventually it did. So here we get into the part on the Constitution of the United States of America. So we have the preamble, the 7 articles of the Constitution, and the 27 amendments. So if you could flip your packet to page 13. So just an overview, I don't have to write anything down right away, but here are the different sections of the Constitution. So you have the preamble, which just states the purpose of the Constitution. It outlines the things that our framers wanted to do and what they intended on doing within our country. Article 1 focuses on the first branch of government, which is our legislative branch. Article 2 focuses on the executive branch. Article 3 focuses on the judicial branch. Article 4 focuses on the relationships among the states with the national government. Article 5 focuses on amending the Constitution. Article 6 focuses on the national debts, the supremacy of national law, and the oaths of office. And Article 7 focuses on ratifying the Constitution. So going back to Article 5, amend means to change the Constitution. And then with Article 7, ratifying means to approve the Constitution. So if there was a new Constitution that needed to be created and approved, there's a specific process that needs to happen. But this hasn't happened since the first Constitution was actually created, when we only had 13 colonies or 13 states that existed at that time. So there are 6 goals within the preamble, which you don't have to write down at this moment, but those 6 goals are kind of outlined in the text that you see on page 13 on the second box under the preamble. So the 6 goals are: first, to form a more perfect union; second, establishing justice; third is to ensure domestic tranquility; 3 is to provide for the common defense; 6, I'm sorry, I'm not sorry. 5 is to promote the general welfare, and then 6 is to secure our blessings of liberty. So those are the 6 goals that are outlined in terms of telling us what our founding fathers set out to do and what they're basically outlining within the Constitution. So there are 3 specific sections of the Constitution that are 3 main bodies. So you can list these under number 2 with the 7 articles. So the first is the legislative body, which is Congress. They're the ones that actually create the laws. So they're the ones that introduce bills to the congressional floor, whether it be the House of Representatives or the Senate, and then they have to vote and approve that. The second body is the president, and he's the one that enforces the laws, and that also encompasses the cabinet offices. So it's the Department of Education, Department of Health and Human Services. All of those are included in the cabinets, and they're within the executive branch, and the president is the head of the executive branch. And then the third body of government is the judicial branch, and this contains the Supreme Court and any other inferior federal courts on the state level, and the Supreme Court is the national court. So they're the ones that interpret the law. So they interpret whether the law is valid or is legal or not. So they're the ones that if you get a court case that comes up to them, they decide whether or not that law is valid. Number 4 is federalism. Federalism is the relationship among the states and with the federal government. So how the federal government interacts with the states and vice versa. There are certain things that the states control and certain things that the national government controls. Number 5 is amending process. So there's a particular process that happens when we change the Constitution, and that usually takes 2/3 of Congress approval and also 3/4 of the states. Number 6 is the supremacy clause. So the Constitution, meaning that the Constitution is the supreme law of the land, and there are no other laws that supersede or are greater than the laws in the Constitution. And then number 7, it shouldn't be number 8, but number 7 is the ratifying process, or the ratification of the Constitution. So this was actually instituted at the beginning process when the Constitution was created, and it goes into effect when 9 out of the 13 at that time states would approve of the Constitution. So you can pause this video or go back and write down those 7 if you have not done so already. So on to number 3 on page 13, it asks in terms of how many amendments there are. So first, starting with the second bullet point, originally there were only 10 amendments, and that was the Bill of Rights. So remember, in order to have the Bill of Rights, the Anti-Federalists had to sign in order to approve it. So originally there were 10 amendments to the Constitution, which outlined our rights as citizens here in the United States. And those are, again, known as the Bill of Rights. Now we currently have 27 amendments to the Constitution, and that could, again, change, and then more could be added, because usually we add depending on new laws or new things that we see should be changed. And that's why the Constitution is known as a living document, because it always can be amended, and there are new laws or new rules that can be added to the Constitution as an amendment. All right, so just to get an idea as to how many there actually are and what they are, so some you may be familiar with, the 13th Amendment, the 14th Amendment, the abolishing of slavery and citizenship, due process, and equal protection under the law. Both were instituted after the Civil War. Another one you might be familiar with, 18th Amendment, prohibition of alcohol. We'll talk about that this year, as well as the 19th Amendment, and then the reversal of the repeal or the reversal of prohibition or the repeal of prohibition under the 21st Amendment. 22nd Amendment limit presidential terms to 2 years, actually to 2 terms, which is a total of 8 years. Voting age of 18, 26th Amendment. So those are some that you may be familiar with. 15th Amendment, no denial of vote based on race, color, previous conditions of servitude. All of those we will obviously talk about as we go through the rest of the year here in U.S. history. But again, the first most important ones are your Bill of Rights, which is the first through the 10th Amendment. So the major principles of the Constitution. So if you could flip to the back of page 13 to page 14, we're going to list and talk about and define and explain the principles of the Constitution. So the first one is popular sovereignty. Second one is limited government. The third one is a separation of powers. The fourth one is checks and balances. The fifth one is judicial review. And the sixth one is federalism. So we'll start with the first one, which is popular sovereignty, which is ruled by the people. So again, if you remember some of the language that we were talking about in the Declaration of Independence, particularly that if government is not doing their job, it is our right as citizens to either amend or abolish it and completely start over. So we actually have the power as people of this country to make sure that government is doing its job. So that's what they mean by popular sovereignty, is that our government, our country is ruled by the people. We choose the leaders that are chosen. Some people may question that with the Electoral College versus the popular vote. But again, ultimately, it's us who makes the decision, and government cannot exist without our consent. So the authority of government flows from the people. So from the people, by the people, for the people are those main ideas of popular sovereignty. The second is limited government. So that consists of the Constitution limiting the powers of government. So it specifically identifies the powers within the Constitution. So Article 1 talks about the legislative branch and what they can do, 2 about the executive branch and what its powers are, and 3 about the judicial branch and what its powers are. So the Constitution really kind of outlines those powers, but it also outlines powers in the different parts or different articles of the Constitution that these different branches or sections do not have as well. So the third one is the separation of powers. So that talks about powers being divided among 3 branches of government, so our legislative, judicial, and executive branch. And it also ensures that no one branch acquires too much control. So again, they all have their individual powers, but they don't have so much control where they overtake the other 2 or overtake different parts of government. Checks and balances is kind of also aligned with the separation of powers. Checks and balances talks about each branch of government exercising some control of the other 2 branches. So I have some examples listed. The first, Congress passes laws, but the president can veto or reject those laws. So if Congress puts a bill on the floor and it passes both houses, meaning the Senate and the House, and it goes to the desk of the president to be either signed into law or vetoed and rejected, the president has the power to reject it because he does not see that it's fit for signing, and does not see that it should be a law, and that there may need to be more work on that bill. So once he vetoes it, it goes back to the congressional floor for more debate or to completely scrap it altogether. So one example that has recently been happening is the repeal for Obamacare and the new laws that they're trying to institute to replace that as well. The second one is the Supreme Court. The Supreme Court can exercise control of the legislative branch by deciding the legality of laws. So if there's a law that is passed through and somebody has an issue and creates a court case against that law, and that court case goes all the way to the Supreme Court, they have the determining factor to evaluate that law and see if it is indeed, in fact, legal. So one example of that can be Brown versus the Board of Education. Some of the states were not enforcing desegregation of schools. So again, people were suing the state governments, And that case can go to the state federal court, and then it goes all the way to the Supreme Court, and then the Supreme Court has a decision to make sure that the states are enforcing it and that it is in fact legal, that they have a right to desegregate schools in the United States. So that is the Supreme Court's job, again, exercising control by deciding the legality of laws. Third one is the president appoints justices and executive officials, but only the Senate can approve it. So the president can't just assign whoever they want to and automatically get whoever they want to as a cabinet member or any other executive officials. It has to be approved by the Senate, okay? So he can't just appoint somebody whoever he wants to and that's it. It has to also have Senate approval. All right, the next one is judicial review. So again, going back to the Supreme Court, kind of the checks and balances, the judicial review in terms of the power of the courts, they can actually declare laws or actions of any local, state, or federal government unconstitutional or invalid. So one famous case I can allude to is Loving versus the state of Virginia regarding the interracial marriage or non-interracial marriage law in Virginia at that time. So people of opposite races, meaning African-American and white, could not marry in the state of Virginia. They had to cross state lines or go to Washington, D.C. to get married, and they couldn't live together or cohabitate or marry each other in Virginia. So that court case was taken on by the ACLU, and was brought all the way to the Supreme Court, where they made the decision that that law is unconstitutional, therefore striking the law out of the state of Virginia. So it doesn't matter if it's even a national law, it can be a local or a state law. The courts have the right to determine the legality or if it is infringing on the rights of people to do what they want to in terms of being unconstitutional or invalid. Federalism is the next one, and that's the powers divided between national and state governments. This was kind of a middle ground between the Articles of Confederation and the new Constitution. So there are powers that national government has, and there are powers that the state have individually or separate of each other. And then there are powers that they both share, which are known as concurrent powers. The states maintain local control, so anything such as a police department is controlled by states and local governments, or education or departments of education per states are actually controlled by the state. There may be mandated things that teachers have to follow based on the Department of Education on the national level in terms of content requirements that we need to do. In terms of like Common Core standards or any type of national standards that we have to do, but anything that's related to specific content standards, there are national standards, but there are also state standards as well. But anything like licensures, requirements for schooling to get a licensure as a teacher, those are mandated by the states and are not controlled by national government. So it differs depending on the state. Same with law licenses. You can go and get a law degree from UW-Madison and not have to take the bar exam in Wisconsin. But if you get a law degree here and move to Illinois, you have to take the bar in Illinois or any other state you move to. So again, they make the rules on that depending on what state you go to. And that's pretty much it. So if you want to go back or you need to go back and write down the major principles of the Constitution, please do so. But we will talk again about these in class tomorrow. Please make sure you come with any questions that you may have about any of the different parts or different sections of the Constitution. And that's it.